Now we start our sixth webinar. So colleagues, friends, ladies and gentlemen, welcome to our sixth episode of COVID-19 series of the live Zoom webinar. Those who don't know me, I'm Seta Bogosian. I'm a principal GP from Surrey Heartland CCG and a senior clinician at South Central Ambulance COVID-19 services. I'm also honored to be a chairperson of Armenian Medical Association of Great Britain. Armenian Medical Association of Great Britain with Armenian Community Emergency Medical Committee has been organizing this series of educational webinars for clinicians, other healthcare workers, and for those from public who are interested. Thank you for those who are participating in this webinar today and submitting questions. Please continue submitting questions in the chat box during this webinar if needed. And we'll try every endeavor to answer at the end. As Lord Darcy said in one of his interviews, that the virus in the first wave was chasing us to the hospitals and intensive care units. We need now to change that mindset and start chasing the virus in the community. As we are now entering into a new phase of recovery and adaptation to a new life, new changes from employer and employee perspective, return to work and potential litigations, those also facing clinical, organizational, as well as administrative difficulties and challenges during this COVID-19 pandemic, we decided to learn today about medical legal changes and touch various and new employment laws and legislation. Although we are protected, we medical professionals, protected by various medical defense organizations and Crown immunity and NHS indemnity. However, we are still remaining dark when sometimes we face an extraordinary challenge. I am delighted today to collaborate again with our sister organization here in UK, BALA, which is British Armenian Law Association. And it's a pleasure to invite Teni Shinyan, the chairperson of BALA. And I have extra pleasure to have her colleague, Mr. Stephen Slater, today to present to us. And we enter into active discussion with medical colleagues from primary care, Dr. Nazeli Manukyan. I'm also delighted to have Dr. Irman Melikian moderator this session. Now, a few words about Irman before we start. Mr. Irman Melikian is a consultant hand and wrist surgeon at Circle Reading and Salisbury New Hall hospitals. After completing his orthopedic training, he specialized in hand surgery at the Pulvertoft Hand Center in Derby, a world-famous center of excellence in this specialty. He published several papers and he became author of several chapters in the books. He presented in various scientific meetings, various papers. He was one of the first surgeons in UK, quite interesting, didn't know about this, Irman. You were first surgeon in UK to attain international certification through the European Diploma in Hand Surgery. Well done. Irman is a fellow of the Royal College of Surgeons of England and he's academic and medical educator. He became a senior clinical lecturer at the University of Southampton in 2012. And associate professor at an overseas medical school in 2014. Irman also served as an active executive committee member in our Armenian Medical Association for over 10 years until he resigned 2 years ago. Now I would like to invite Irman and Nazeli, Stephen, and Teni to join the platform. Please, the platform is for you now. Irman, you start.
Thank you very much, Seta. I hope everyone can hear me nicely. Thank you very much for organizing this series of webinars, and I'm honored to chair this meeting, and I'm in a very privileged position because I can sit back and get our esteemed contributors to present. So I will only say a few words about our presenters. As Seta started off, I will just give you a quick rundown of who they are and what their backgrounds is. So Tenny is a co-founder and partner at OTS Solicitors, and she has dual degrees in law and business. She has worked in the field of immigration and also employment law. And she's been within the legal 500 recommended solicitors in the UK. She's a member of the Law Society's Human Rights Committee. She's been on various BBC shows and panel discussions, including Victoria Derbyshire show. She's also the coordinator of BALA, the British Armenian Lawyers Association, and she runs various projects both in this country and in Armenia. So thank you, Tenny, for joining us today. Her colleague, Stephen Slater, is also a senior lawyer at OTS Solicitors. He's a member of the Immigration Law Practitioners Association, the Statute Law Society and Employment Law Bar Association. He has a complicated caseload and appears for the first tier tribunal. His professional training for the bar course is near completion at the City University, and he is a specialist in employment law and nationality law claims. So thank you very much for joining us, Stephen. And also, last but not least, we've got Dr. Nazili Manukyan, and she's a GP in Surrey, an appraiser and a specialist for headaches at the National Migraine Centre. She obtained primary medical qualification in Armenia, where also she did quite a bit of research in neurology. She further trained in the UK and obtained the membership of the Royal College of Physicians and Royal College of General Practitioners. Her specialist area is in headache management as well as family planning and menopause planning. Thank you very much, Nadine, for joining us. So without further ado, I will go on mute myself and I will open the floor to our first presenter, Nazili, who's going to talk to us now. And we will then continue with Stephen's presentation before we come to answering some of the submitted questions at the line. So sit back and enjoy the show. Thank you.
I think, Tenny, it's your turn to present.
Okay, good afternoon, everybody. And firstly, I just wanted to thank you for the invite to be present today for this presentation. I'm going to be starting to talk and I'll share my slides and then I'll pass it on to Stephen. Okay. Can everyone see the slides, just to check? Yeah. Okay, great. So I wanted to discuss about redundancy as we're facing this quite common now in light of COVID-19 and the considerations for employers to have during this time. To begin with, the definition of redundancy. under Employment Rights Act, it's quite lengthy, but in short, an employee can be dismissed as redundant when a business closes down, or if the employee's actual job of that particular kind of job has diminished or is expected to cease or diminish. The most common reasons given for redundancy is reduction in workforce, restructuring of the company, which is happening quite a lot at the moment, a lack of work, or a technological change that has replaced the need for the worker. So in order to claim redundancy pay, you need to have 2 years continuous service. If it's under 2 years, a lot of it is down to what the employment contract itself states. Some of the time, or a lot of the time actually, it would be just a dismissal if it's under 2 years. However, if it's not followed correctly, it could lead to a breach of contract. It could still lead to unfair dismissal if it's a protected characteristic and the employer hasn't followed the procedure correctly. So under the Equality Act, there would be a number of protected characteristics: race, religion, sexual orientation, and numerous others, which I'll come on to in a bit. The redundancy process itself is in 3 stages, mainly. Firstly, to send out an all-out consultation on the people that are potentially going to be made redundant. Then followed by individual meetings with those at risk of redundancy. At the meeting, the employer, firstly, to explain why they are at risk of redundancy, what the situation is. Second purpose is for the employee themselves to have an opportunity to give their own representations as to why they should not be made redundant, and what other potential job opportunities the employer might be able to provide to them within the company that would fit their skill set and offer a salary that the employee may potentially be agreeable to. So these procedures are quite important to follow, following which you would make a decision on redundancy. During these procedures, if there are times where you potentially would be affecting a particular group that falls within a protected characteristic, there might be claims for unfair dismissal on those grounds. So whether that's 2 years or less, you could still face an unfair dismissal claim. This is the part that's very important to carefully look into before going through a specific group of members of your company or employees of your company to go through redundancy. A time frame for redundancy is really down to how big the organization is. It can last a number of weeks or a number of months. So that's quite varied. Health and safety considerations. So Stephen will speak more about risk assessment, but in relation to it under redundancy, under Section 44 of the Employment Rights Act, an employer has an obligation towards its employees under health and safety laws. These are a number of assessments you would make in order to distinguish whether a person can return back to the office environment or the workplace. Firstly, categorized as vulnerable. I know that this is subject to constant change during COVID-19, and it may require that you obtain a doctor's report to confirm that you are vulnerable if it's in dispute. Having tested positive to COVID-19 in the past 21 days is another consideration. If you're shielding somebody, if you are using public transport, an alternative means of transport to be looked into, the welfare of the staff in the workplace and your own welfare, whether the task can be done remotely. So this part is quite important because it can later lead to redundancy. If the task cannot be done remotely and we reach the end of furlough scheme and those employers do not have the income or the possibility of giving you work to do remotely, then you might be forced into a situation of redundancy where the employer can provide the work that you were doing to one of your colleagues to take on, and therefore makes your role redundant because you cannot go into work for the reasons set out, and the employer cannot provide you work to do remotely. So these are things that we're expecting to see a lot more of in the coming months. And there may be other essential concerns that you should be discussing with the employer. So justified reasons as to why you cannot return to work. An employer should be trying to find alternative jobs that you can do for the company without having to go in. And employers, as I said earlier, do need to take into account characteristics, but the most common one right now is the racial discrimination. Race does fall into 3 categories now, so colour, nationality, ethnic or national origin are also characterised under race definition. So if these are quite common, especially during COVID-19, and the recent statistics on how many are getting infected by this within the ethnic minority groups as well. So when considering redundancies, the potential of having affected one particular ethnic minority group is also a very important point to be aware of and seek advice on. ACAS is a conciliatory body who provide impartial advice to employees as well as employers. They're independent from the government and they are a free advice service. If you have a dispute with your employer or employee and you want to speak to someone impartial who can perhaps find a resolution, they are a very good organisation to go to try and find a resolution. If you did have a claim that you wanted to take to the employment tribunal, you must go through ACAS first, who will try and negotiate, and if that's unsuccessful, will provide you with a certificate in order for you to put in a claim. So that's an important part to bear in mind. That's my presentation at the moment, but I will obviously answer questions a bit later. I'm going to pass you on to Stephen, who's going to talk to you about health and safety and risk assessment. You're on mute, Stephen.
Sorry, thank you, Tenny. I'm now going to try and share my screen in the same way that you've shared yours.
Oh, I've got yours presentation, so you can go ahead.
All right. Okay. So, well, first of all, by way of introduction, I thought I would explain how I'd like to structure my contribution to this discussion. And driving here on the radio news this morning, I heard that the government is now sending quite a significant change of tone in their messages, which is they now want people, if they can, to attempt to return to work. And I'm going to approach the duties which employees and employers have in broadly 3 sections. First of all, if you're trying to do the right thing, what's the framework that should inform that discussion? Second, what in the contract of employment between an employer and employee would constitute reasonable adjustments? And thirdly, how both parties should contribute to a risk assessment. So taking the first point in relation to attempting to do the right thing, one of the people that participated in this, in the run-up to this seminar, asked the question whether or not an employer could compel an employee to submit to having their temperature taken. And that's quite a useful way to illustrate the dilemma that we have in trying to do the right thing. Because actually there's no legal basis for an employer to insist on a temperature check at all. An employee can be encouraged voluntarily to do that, but if the employer took disciplinary action against an employee for failing to submit themselves to a temperature check, then it wouldn't be proper for the employer to take disciplinary action against them, because there's nothing in their contract of employment which says that they should submit to a temperature check. So can you see, in the existing law, there is sadly an absence of a framework for all the new dilemmas that we now have to face. Now, that doesn't mean that if a firm introduced voluntary temperature taking, and then you discovered that an employee was running a temperature, well, then clearly there is potentially a risk to them and a risk to other employees. And then it would be more appropriate for the employer to say, well, we've discovered that you have a high temperature. We think you should take yourself off to be self-isolated or to be tested. So in the absence of specific guidance in relation to employment law, the government has set out what they describe as 5 steps to working safely. And I hope you can see the slide that shows that. And you'll see that one of the things that they require is carrying out a risk assessment in line with HSE guidance, consulting with your workers and trade unions, and sharing the results of a risk assessment with your workforce and on your website. Now, the 5 steps which the Department of Business have published then go on to advocate developing cleaning, hand washing and hygiene procedures. And thirdly, helping people to work from home. And fourthly, to maintain a 2-metre social distancing where possible. This is the guidance that was published as at the 10th of July. So 2-metre social distancing where possible hasn't been reduced to 1 metre plus in the way that it has in other areas. So currently that's still the advice for workplaces. And they say finally, where people cannot be 2 metres apart, to manage transmission risk. For example, by reducing the number of people each person has contact with, by using fixed teams or partnering. Now, I'm just going to go on to the next slide. Now, individual sectors of the economy have been provided with industry and sector specific guidance for 13 different sectors, ranging from office and contact centres to the performing arts, people in sports and leisure, restaurants, pubs and bars, shops, and also the visitor economy. So the government's starting point here is to say that you should make a risk assessment. Now, before you can undertake a risk assessment, you need to establish whether or not members of your workforce are people for whom the employer would have a duty to make reasonable adjustments. Now, reasonable adjustments will arise from a number of different characteristics. So, for example, pregnant women have been identified as a vulnerable group. Certain ethnic minorities are seen by the Office of National Statistics to be statistically a greater risk of fatality in the event that they can contract COVID. So therefore, employers have to make as a starting point an amendment to their sickness and absence policies to take into account those additional vulnerabilities. So pregnant women, for example, could argue that they shouldn't be exposed to too much contact with customers if potentially that might put them at risk. And it's possible for an employee to argue that if they have a protected characteristic based on their gender or their race, that the employer should make those reasonable adjustments. Now, the other grounds upon which somebody can enjoy a higher degree of vulnerability is if they have a medical condition which makes them particularly vulnerable. And that's the category of people who previously were involved in shielding. So if somebody who previously shielded wanted to return to work, then it's important for the employer to assess the nature of the disability which they have. Now, the government has published the health protection coronavirus restrictions in England and Wales, and they contain a list of people who are regarded as vulnerable. So because there's a statutory definition of somebody who enjoys a vulnerability, then it's most likely that a person in that category would meet the criteria for disability under the Equality Act. So if you can identify particular vulnerable employees, then you should, under the Disability Discrimination Act, you should be making reasonable adjustments to protect them in the workplace. Now, the penalty for an employer failing to satisfy that duty can come from a number of different sources. First of all, an employee who argues that their vulnerability hasn't properly been addressed can potentially have a cause of action under Section 101 of the Employment Rights Act 1996, where the employee would argue that it's reasonable, because of his status as an extremely vulnerable person, that he would refuse to come to work until the employer had made the necessary adjustments. And a vulnerability based on a potential greater exposure to the virus or greater risk as a consequence of exposure to the virus would give rise to that cause of action. Now, Section 21 of the Equalities Act also provides a remedy in relation to disability discrimination. So the employer can not only face an employee who has reasonable grounds for not attending work, but if compelled to attend work or suffered a detriment as a result of not attending work, then that would give rise to a claim for disability discrimination under Section 21 of the Act. Now, there's been a lot of debate around personal protective equipment and the provision for the same for employees. Now, that's another piece of legislation which, in fact, has been in place for a very long period of time. The Personal Protective Equipment at Work regulations came into force back in 1992. And they require that the employer must provide equipment which is suitable ergonomically for work, is fit for and controls the risks of infections, and that if more than one piece of PPE is worn, it must be compatible with the other pieces. It must be assessed as suitable and maintained and replaced as appropriate, and the employer is under a duty to provide training in its use. So with some of these regulations, there are new COVID regulations, but in relation to personal protective equipment, the government is still relying upon the traditional health and safety legislation. Now, there are, in recent times, there are examples of actions that the Health and Safety Executive have taken where a workplace has failed to institute the proper arrangements. So you will have read that there was a meat processing factory in Anglesey that sustained a COVID outbreak. Similarly, clothing factories in Leicester have sustained the same. Well, in addition to the civil causes of action, which I've outlined, there is also the prospect of a criminal prosecution, as was brought against a leisure centre in 2002 in Barrow, where there was a Legionnaire's disease outbreak. And the reason that I think that's a relevant and salient point for people to address is that if you're dealing with an occupational hazard, which it potentially has fatal consequences, then if there is an outbreak in a particular workplace, then a health and safety investigation, including a criminal investigation, can sustain if the employer shows that they haven't taken the necessary steps by way of precaution. So it's interesting, the government is summoning people back to work, but they haven't informed the general employer population of the consequences that may flow from that. And the best way for both employers and employees to protect themselves is to collaborate around the compilation of a risk assessment. As it says in Section 2.1 of the Health and Safety at Work Act, it shall be the duty of every employer to ensure that as far as reasonably practicable, the health, safety and welfare at work of all his employees. So if you keep that definition front and center of your mind, then you can set your workplace on a path to safe mitigation and risk assessment. Trying to do it ad hoc and just listening to the radio advice is not going to be enough. Employers and employees do have to document their risk assessments and crucially keep them under review. So I'd be happy to field questions on any of these aspects of the interplay between health and safety at work and COVID-19. So I'll hand back to Tenny.
Okay, that's it from presentation-wise. If there are any questions that we would point out for now.
Thank you very much, both. We have received some questions from members of the audience, and we have assigned or discussed who would respond to them, and we will probably not be able to cover all of the questions in a great sort of detail, but I will endeavor to go through them. Is that all right if I quickly go to the questions? So the first question that we received was about the temperature taking in the workplace. So they wanted to know, how ethical is it for an employer taking a temperature before allowing the employee to enter the building? Is it sensible for the employee to take their own temperature and document it if this is possible? And this was a question I think Stephen kindly agreed to go through.
Yes, well, I only addressed in my remarks whether or not it could be made compulsory. But the question of where the duty lays, I would say that taking a temperature, if the policy of the organisation is so to do, that should be an employer executed duty, because that allows the employer to keep a record, and then the employer is going to require access to that record if they then subsequently need to take action and need to ask whether or not an employee is allowed to continue to stay in the workplace if they begin to exhibit appropriate condition, if they exhibit potential COVID symptoms. I would say people taking their own temperature, the difficulty you'll be there is what happens to that record. The employer will have in place Data Protection Act data controller regulations which allow the employer to keep occupational health records. So it seems to me that's the natural framework where you would keep that information, because an individual who compiles that data or presents a self-assessment may not take the reading properly. Lay people may get confused with the, they may or may not be operating proper equipment. I think it's much more appropriate that falls on an employer's shoulders if it's going to be adopted as a voluntary policy. But at the moment, there's no scope for making it compulsory. I think it would be an entirely different framework if you, for example, wrote into somebody's contract of employment that it was a condition of employment that they did these things. Then there would be arguments about sharing that information, and you can then begin to put responsibilities onto the shoulder of an employee. But as a general principle in employment law, if you have something which is an employer duty, trying to design a framework where that statutory duty gets delegated to an employee, I'm afraid is probably a fool's errand.
Thank you very much, Steve. So I will move to the next two questions, which are somewhat related, and again, it'll be yourself who will respond to them. So one of them is, how should the employer react if somebody's got, as a result of their own experiences, perhaps a fear of the public as they may contract COVID, or indeed if they have suffered a recent breakdown or a PTSD, although that is a very precisely defined medical question. So that's one question. And the second one is, again, related to that: how should the employer behave in response to the high-risk populations, such as BAME, disabled people, pregnant women, all the different categories that you also showed very clearly that were affected in various degrees, shall we say. How does the law fit around this, or is there any conflict with employment law or equality diversity law in this regard?
Well, if you mentioned PTSD specifically, but taking any medical condition which has a psychological rather than a physiological foundation, the definition of disability set out in Section 6 of the Equality Act, and that's described as a physical or mental impairment which has a substantial and long-term adverse effect upon the ability of that person to carry out their normal day-to-day activities. And the Act also helpfully defines what it means by the word substantial. So the definition in the same statute is that substantial means more than minor or trivial. So the steps that you would have to take is, first of all, establish whether or not the mental impairment was a substantial, it had a substantial and long-term adverse effect upon that person's ability to carry out their work. But then, just because they have a disability, and sometimes a reasonable adjustment for that person can be, well, if you have that vulnerability, the adjustment that we make is that you can work remotely. So you're not exposed to stressful situations. So in order to prove that that person has suffered some disability discrimination, you have to go a further step, not merely having the condition, you have to show that you have suffered some detriment. You can't bring a claim under the Disability Discrimination Act merely because you're being told no, and merely because you're not satisfied that the reasonable adjustment that was made was sufficient. You have to go further and show that you have suffered some detriment and that there was a relationship of causation between the two, that you were suffering that detriment because of your disability. Because it may well be that all employees, both able-bodied and disabled, were being asked to do the same thing because of the COVID restrictions. Do you see? So, so the key points to bear in mind, just to summarize, are yes, a mental condition as well as a physical condition can qualify, but in all circumstances, both mental and physical, you have to satisfy the tests as I've just outlined them.
Okay, thank you very much. I will move on to the next question, which is about medical issues and medical reports, and that will be Nazir Malakan responding to. The question reads, normally when the employee has medical issues, the employer requests a medical report from the GP. In these days, in the COVID situation, several days time off, those express mild COVID-like signs or symptoms or self-isolating, the GPs have very little time or resources to respond to these requests for reports, and how should they deal with these requests? Is there a law supporting this this issue now?
Yes, there is specifically. GPs should consult Regulation 7.2 of the SSP General Regulations 1982. And under those regulations, the time limit for notifying an employer about sickness can be extended by 1 month if there is, quote, good cause for delayed notice. And sickness absence policies have had to be revised and should be revised in relation to COVID. Because if somebody is self-isolating and, for example, if they're exhibiting symptoms, the GP is going to say to them, well, you can't attend. So there will be difficulties in obtaining GP certificates for absences. You'll have difficulty attending face-to-face meetings. There are potentially going to be higher levels of sickness absence, which may breach a company's sickness absence policy. Well, in which case, that policy needs to be revised to reflect the constraints of the COVID pandemic. And there are going to be difficulties in accessing isolation notes, delays or omissions in NHS Digital's Shield patients lists, because it's taken a long time for people to get round to testing, tracing, isolating. And if sickness absence policies and occupational health policies, which are often insurance-based, trigger a requirement for documentation, then employers have to put a whole lot of new machinery in place. And candidly, I think as part of the risk assessment process, it would be just as important to revisit the firm's sickness absence policy and take advice from medical practitioners around what their custom and practice is, what constraints they're working within.
Thank you, Stephen. Nazir, what's the situation in your daily practice these days? How do you deal with these requests?
Yes, we've been running consultations remotely and still seeing patients, those we can't assess via video link or only telephone consultation. But as regards to the sick notes and fitness certificates, so we have a digital way of, at the peak of COVID, we could still create one and support the patient and send it to them electronically via email or a message link. All those who can't have these facilities and can't manage, they can still, someone can come and pick it up from surgery, still open, and we work from the office. So it's not a problem producing one and forwarding to patient. So those who have symptoms of COVID are told to isolate for 7 days. So they can self-certify for first 7 days. If the illness is more prolonged, then GP will get involved and sign them off work, so they're not fit to work. Those who are contacts of COVID patients, they have to isolate for 14 days, but they are not ill, so therefore I cannot provide them certificate. So there is a way of obtaining isolation note via 111 website and an NHS link. And those who have more prolonged illness and have been tested positive, then GPs can support. As regards to some other reports or legal reports and non-COVID related, we're still doing them. At the peak when we were quite busy, they were delayed, but there are still some situations or holiday cancellation reports, non-NHS private reports, we're still dealing with them. It depends on individual circumstances and how urgent they need to be.
Thank you very much. Okay, so moving on swiftly to the next question, and there are a couple of questions in a row for Tenny to respond to. So I will throw them in the same bucket, and so one of them says, several of my colleagues and myself are feeling nervous returning to work. We are on 0-hour contracts. Our employers threatening us with the risk of dismissal. Where do we stand? So it's connected. So following up from there is a question saying, a small private company, we would like to know who should provide the face masks for my employee. Can we get reimbursement for the costs? And finally, again, related to that one, how do you force somebody to wear a mask if an employee is very stubborn? I think this is probably more not so much a cost issue, but related to health and safety. But so those are the three questions.
Okay.
Thank you.
First one, in terms of being forced to go back in, if the concerns, anxieties are medical related, if they are under the list by the government of those who are vulnerable, or if you have a medical certificate to say that you are at risk and should not be returned back, or you have a medical specific PTSD, for example, then yes, that could be a good justified reason for not returning back to the office environment. In that situation, an employer needs to look into alternative ways that you can work remotely, or if they are unable to provide you with work remotely, then for the time being, at least being able to take account of the furlough scheme if they're already on it. But in this, there will come a situation where that person will then have to start going as a sick leave, and the length of that sick leave and at what point the doctor would be able to say the person is able to go back to work is something that you look into, because it may reach a point by which the employer would say, I can't continue to keep you on sick leave, and depending on what their policies are. And then the doctor can potentially say there is no longer a heightened risk. So at one point would have to return back to work. So I think that it's delicate in nature and it needs to be assessed very carefully, with both parties agreeing to a resolution to that. Anything that you wanted to add, Stephen, to that point? You're on mute. You're on mute, Stephen.
Right, just to reiterate, the questioner asked who has the responsibility to pay for masks, or how the cost of them can be offset. The regulations say that the masks must be provided. So that does mean that it's an employer duty to provide them. And that's going to be a below the line cost in terms of tax liability, but it wouldn't be proper to ask the employee to provide their own PPE. The regulations are quite clear that the employer must provide that equipment. So logically, the cost must fall on the employer's shoulders too.
I'm sorry, Erman, there was one other question. Have we missed?
Yes, so let me have a quick look. So we've responded to the the cost issue, but I think the last one was how do you enforce the wearing of a mask?
I think it's health and safety, and if there are other colleagues in your workplace who are going to be at risk by you not wearing the face mask, then the employer would have to, and if it goes on that way unreasonably, an employer will have to start to look at disciplinary procedure for that employee, because it needs to be equal to all parties and fair and safe environment to work in.
I think, I mean, some of it is probably enshrined either in government guidance or law. I don't know whether it's law, but guidance certainly. So for instance, the compulsory nature of wearing of masks in public transport, in hospitals. So
I think they're going to put it into shops shortly as well. So.
Shops probably shortly too. Yes, so that will be, I think that's all, I don't know whether it's law or guidance, but it's certainly out there, and I don't think nobody argues against that. If there was a situation where, say in an office environment, then that might be more fluid, perhaps.
Yeah.
But just to make an observation about the interplay between the two, just because the government gives advice and guidance, that doesn't then become law. The point is, an employer-employee relationship is a contractual relationship. So you can import the guidance into that contractual relationship, but you can't say, well, because this guidance has come from the government, that it has a legal status, because it is just, at the moment, it's just guidance. And until they introduced the Coronavirus Act 2020 and associated regulations, where they put into force, for example, during the lockdown, there were breaches which had specific sanctions and penalties. But the problem is that we're outside those very simple and strict to enforce parameters. Now we're into a field where the government is saying to employers, well, use your best endeavours, conduct a risk assessment. So it's then quite hard to be prescriptive. However, if you simply put an addendum to a contract of employment and adopt it as a policy, then it's something which you can then make a condition of employment. And that's the much more sensible way to consult around the risk assessment. And once you've adopted a policy, then what you're doing with the employee is taking action for a breach of a company policy. And frankly, you can adopt a policy which is more rigorous and more prescriptive if you want to. And then that gets imported into the contracts of employment. And that's a much more natural venue around which to have the discussion, rather than to seek the legitimacy of, is this done in the name of the guidance? The guidance just sort of helps you inform what would be a reasonable requirement. And all the employer has to satisfy is that it's a reasonable requirement to add that to the employee's conditions, to their terms and conditions of employment.
Thank you very much. I do remember there was program recently about the guidance that the government issued at the time, and that they never had the time, obviously, to pass it through Parliament to make it into law. That was never the case, and therefore, even at the time of the lockdown, it was very difficult to see which was guidance and which was law. Obviously, the government has some emergency powers, but they are limited. They're not encompassing everything. We're gradually coming to the end. There were a few questions which we probably won't go into this time round. So in particular, there was, just to mention a few, there was one about the London waiting and insurance policies in London specifically. I think that was felt that it was quite a specialist area, and so we're going to address that hopefully in a different context. Unemployment benefits, again, it's it's to do very much with benefits and universal credit, and wills for people who've died, whether a will is sufficient without lasting power of attorney. Again, that's quite a specialized question. So we apologize to people who were expecting those to be answered. Just to finish off with, we've got one that has come at a late stage, and that involves the workplace sterilization measures. So the question reads, could massive and urgent investments in ultraviolet sterilizing technology to sterilize surfaces normalize the working environment, in particular medical procedures, appointments, etc., to get people back to work? Now, I'm not an expert in this area, but the problem of hospitals not returning to routine elective work for a very long time was not related to the uncontrollable and excessive risk of COVID. It was related to a much more mundane problem, which was that the NHS took over the private hospitals, and they basically, quote unquote, they were paralyzed to a certain extent. It was basically to make sure that if there was a wave of COVID patients, that these patients did get urgent treatment, be it in an intensive care unit or otherwise. But specifically with UV sterilizing equipment, this is possible, but in my view, it's not practical to sterilize a room, an outpatient clinic room or a procedure room. You would need fairly advanced sterilization equipment, which would sterilize after each patient the room and all surfaces. It would mean that you have ultraviolet light shining on surfaces from all directions for a sufficient period of time and with sufficient intensity. And in my view, this would bring in, it could be counterproductive as well, because ultraviolet light, as people might know, is cancerogenic. So you could argue that it would lead to mistakes and accidents, because if somebody were to enter that room whilst it's being irradiated with ultraviolet light, then I think that would be very, very dangerous. And also, there are much easier ways to make sure that surfaces are cleaned, because you could just wipe them with antiseptic solution, and generally speaking, that would lead to cleansing. So with chairs and tables, that would be much easier. If you needed the walls to be sterile as well, which we don't, then obviously ultraviolet would probably qualify in that area, because you couldn't possibly wipe all the walls down, but luckily there's no need for that. And with droplets in the air or aerosol generating procedures, I'm not sure that ultraviolet would be helpful, because it would depend on the air currents in that area as well. So I think technically it's very challenging to make it work. If it was only one area, one room, if it was like a production room where you produce, I don't know, microelectronics, for instance, you could keep that room closed and hermetically sealed at all times, and run your ultraviolet in between procedures. But unfortunately, hospitals are simply not such places. They're not built for that purpose. So I think technically very difficult in my view. I don't know what the lawyers would say in terms of adaptability of employment laws to that.
Well, I'm told that if you copper plate surfaces, that supposedly that's a safer environment and can potentially kill COVID. But lawyers very rarely give copper-bottomed answers to questions like that, because whether or not whether or not that's a reasonable adjustment it is something that I think, if it were required to make a workplace safe, then I would want to bring in expert evidence, not just an employer-employee assessment about a reasonable adjustment and about safety precautions, but always stand on an independent scientific judgment. Armed with an expert report, then by all means, I might try and give you a copper-bottomed opinion.
I think I just agree with what Erman said. It's just the practical measures of doing that as well in any given environment, and whether that's really feasible at the moment anyway. Yeah.
Thank you everybody. We're, I think, on the dot at 60 minutes, so I'll hand the microphone back to Seta in case she wants to make any further announcements. So thank you for attending, everybody.
Thank you.
Thank you. Well, nothing left for me to say, but just to thank you, all the panelists. Thank you, Irman. Thank you, Stephen. Thank you, Nazeli. Thank you, Tenny, for devoting your time and presenting to us today for the health of our nation. This is a great achievement. Thank you so much. And thank to all the participants who appeared today and their questions. And please, please give us your feedback, which help us tremendously to improve our future webinars. I would like to convey a special thanks to Armenian Community Emergency Medical Committee and ACC, Armenian Community Council, for hosting this webinar by Zoom and sorting out any technical issues we have, which is always, I mean, this is our 6th webinar and they are so patient with us. Great, thank you. We are conducting these webinars bi-weekly now. And our next webinar, before we pause for summer, August month, we will be having one in 2 weeks' time on 26th of July, same time. And you are all invited. And that will be 2 presenters. One is on musculoskeletal injuries by Miss Annie Kenyan. She's a registered osteopath and has her own way of relieving people's pain. And Dr. Armen Nersesyan, he is a special guest from Armenia. He is psychiatrist, psychologist, medically graduated from Yerevan, and he's going to talk to us about Nareka therapy. So I would like to invite you all again to join us. So once again, I would like to thank you all and thank our panelists. And I wish you a very happy rest of the Sunday and the coming week. Okay?
Thank you very much.
Thank you. Thank you.
Take care. Bye.
Bye-bye.